Hey guys, new year and new information from Sarah Boone. You remember the happy picture of her meeting her latest attorney, shaking hands, couldn't be more stoked. And now she has a new judge in the case, so everything is coming up roses for Sarah, right? Should be seeing her at the trial. Nothing to do now but to put the head down and get prepared and put this defense together, right? Wrong. Sarah's pen, she still needs an endorsement for that. It's not out of ink yet. She's got something to say to this new judge who perhaps is not fully up to speed on the case. And with the eye toward a new judge, the new lawyer becomes kind of old news. And I think this is going to be a little bit of a happy tale for the new judge, but sad to see a blossoming relationship perhaps losing the bloom. Well, let's see what Sarah's got to say here about her case, because, it's coming up for trial in May, and this judge said, we're not going to keep continuing this thing. It's got to be stoked, right? Let's see. All right, so here's addressed to the new judge, not the whole world or anything like that. Dear Honorable Judge, finally, a new judge. It's strange how the Lord works, as I was in the process of trying to disqualify Wooten after being my judge 4 years and me still incarcerated with nothing to show. She was in the process of trying to disqualify him. How was she doing that? I didn't see any motions or anything like that. Maybe through the power of positive thinking to manifest it, right? You believe it, it becomes true. So she was probably in the middle of that. And look, it worked, right? She's got a new judge. Other than 7 in quotation, parentheses 7, in case the judge doesn't know what the word 7 is. Different attorneys, not by choice. News clips of me walking in and out of the courtroom. And what else is there to show? And everything relative to my case permitted to be slathered on the global internet, and in which I have not seen myself. So she didn't say, I haven't seen it myself. She said, in which I haven't seen myself. So she's not seeing her true self in these clips that she's seen. And that's sad, right? Because we know she wants her truth out there. I felt he was the ticket holder to my overly hyped, illicitly distributed, misconstrued criminal case. And great reason I am still here. Illicitly distributed, okay? And like every other case, everywhere. I'm still here again, ongoing 4 years and 7 attorneys later, not by choice, she repeats again, in case the judge forgot. I mean, you don't know whether this judge has some kind of attention span issue. See my letter dated 6/9/23 on clerk's website. This is all in capitals, so the judge is alerted that the judge should go reference these things, right? Get up to speed, judge, come on. While still waiting to properly elucidate the court, public, and the world after whatever the dysfunction was in the attendance part of my most recent pretrial conference status hearing, which I am trying to ensure my automatic attendance futuristically. Please see my draft motion. That's in capitals too. So this is not apparently a real motion, but just a draft that the judge might be interested in seeing, included as I am still trying to have my attorney submit on my behalf. Now this is, the storm cloud begins to gather, right? It's not an immediate announcement of an issue with this attorney, but you can sense in here, I'm still trying to have my attorney submit this on my behalf. So you see some disconnect already. I wanted to bring to your judicial attention the following information so you and the world are aware. It is not I who am ever delaying trial, as Wooten inappropriately accused me of doing in a past hearing. Especially now you have mandated a trial date to be had in May with no further continuances, leaving less than 4 months to put together and complete what should and could have been done already. Leaving just 4 months. Now, are you sad this judge set the trial in May? Or you don't want it delayed, but now you're butthurt that it's coming in May? Okay. Trying to have it both ways, I think. What happened in all the 4 years prior? Please see all my correspondence online. I feel like this letter is a good indication of what has been happening. All right, now we get into Sarah's not gonna write a letter without some Rain Man-esque qualities. And here we begin with the new style bullet point for 2024. Look at this, colored in, hand-colored, handcrafted, Etsy-esque bullet points here for what she's got to say. To date, Winston E. Hopson has been my court-appointed attorney for 133 days and counting. And counting, Judge. Okay, don't stop counting, okay? Because every day is a new day, right? To date, Mr. Hopson has only met with me one, Judge, in case you don't know what one is, time, for a total of 3 hours. What does that mean, 3 hours? If you don't put it in parentheses, or write it out with the word first, and then put how are we supposed to know what it was? 11/7/23. To date, no phone calls have been received by Mr. Hopson, as his phone does not work properly for further immediate, much needed communication to be made between client and attorney. So here's another attorney who she is saying she cannot get in contact with by phone. This pattern emerges here, and it reminds me of the old demotivator poster that the only common link in all your failed relationships is you. But anyway, the critiques of Hopson are starting to line up here, right? He's only met with me one time in 133 days. His phone doesn't work appropriately. Maybe he has AT&T. You ever thought about that? That wouldn't be his fault then. To date, I have mailed 5. Now we're back to, I can understand what she's saying again now. Letters to Mr. Hopson. She's mailed 5 letters to Hopson, this poor guy, trying to communicate my urgent need to speak to him. Page number 2. To date, I sent one letter to the investigator in my case to contact Hopson to contact me and see if he can assist in correcting the phone problem. Also to inquire when anyone is coming. I feel like we're getting a to date a lot here. Right, to date, right? That's the date you're writing the letter. I don't know that you need to say that, but hey, it's your thing. You do your thing. It's your truth to say to date. To date, I feel I am not being included or heard or cared about in my case again from the continued miscommunication again with Mr. Hopson, and time-consuming, undiscussed entries are being made on my behalf. The continuance I did not know about. The waiver of appearance I did not know about, along with other documents. And I am never sent copies of anything filed, so I know I keep trying to tell him about with no response, furthering the already massive dysfunction in my 4-year case. Now, if you're Hopson waking up and reading this, do you become more or less motivated to help good old Sarah out here? I was hoping in the PTC Status Hearing on Tuesday, 1/16/24, I could at least play catch up in the courtroom for 5 minutes. So many of my attorneys have done prior, including Mr. Hopson, in the one court date I've had for continuance, 10/30/23, to express and emphasize the need for him to communicate and schedule a second very overdue meeting. I still have not even heard from Mr. Hopson about our missed PTC status hearing. What's the status? To date, 1 out of 133 days and counting, attorney and his client have met. Okay, I think that we're repeating here, but whatever. To date, 3 out of 3,192 hours. Are we still counting or are we stopped? Now I'm confused because it doesn't say still counting. Attorney and client have discussed partial general case information. To date, I still have not seen my discovery. Your Honor, when is the next status hearing, please? Especially since we were not at the last PTC status hearing. Who's the we here? Who's the we? Are you French? You got some extra personalities in your pocket? Whatever. And especially since I am trying to communicate with my attorney in more than one way to fully maximize and utilize the minute amount of time allotted before trial. My fair, appropriate, and lawful trial. Of course, lawful law comes from People versus Brooks, Darrell Brooks, who with a stunning precedent case that says that law must be lawful. A point that he brought out in his case, and I think we all can appreciate that scholarship, and for Sarah to use it is certainly wise. I still am wondering, though, I've had to wait for 4 years for something to finally happen on/in my case. Ask Judge Wooten. I wonder also, was I the oldest case on his docket? You begin to feel so lone, so underappreciated. But look, it's coming in May, unless you don't want that to happen, right? I think your butt hurt both ways. Either way, I'm still here waiting patiently and very excited to get this highly anticipated show on the road. I await your overdue and very needed judicial direction, supervision, and intervention. Well, I don't think the judge is going to direct you or supervise you because the judge is not your attorney. So that's not going to happen. Maybe a GoFundMe to get the kind of attorney you want. But again, it's starting to, the body count we're really stacking bodies here in terms of attorneys who have been unsatisfactory for Sarah. And I think, there's an issue here. Attorneys, believe it or not, are people too. And there's a lot on the lines here, and maybe you can read between the lines to some degree as well about this. Here's this draft motion. And again, we have the draft artistic. She doesn't have a stamp, I'm sure, but she's able to simulate one on the left side of the page with the word draft. In the circuit court, the 9th Judicial District, blah, blah, blah. Motion to be included in and allowed admittance to all defendants' pretrial conferences and hearings comes now defendant Sarah Boone by and through her undersigned attorney, Winston E. Hopson, and request permittance to attend all my pretrial conferences. Blah, blah, blah. So she wants to be at the conferences, which, I understand that. She alleges as follows. These pretrial conferences are for my personal individual criminal case. It's an individualized case, right? This isn't some mass thing. A great point there, because I think that's a good one to point out the judge. The judge doesn't know that your pretrial conference is for your individual case. If professional YouTubers, news channels, court TV, etc., are given permission, how about amateur YouTubers are given permission and allowed entry to the courtroom for viewing, and the judge also is allowing the conferences to be streamed live with all the court minutes uploaded to the internet and world, I, the defendant, should be included foremost. I mean, again, I understand that. I can't see why she can't be there. I may not have regular, consistent updates or communication with my court-appointed attorney, and by attending all my PTCs and hearings, I will know current status, important dates, casework. So I don't know that the attorney is going to sign this and send it in on her behalf when it has the allegation in it. I may not have regular, consistent updates or communication with my attorney. And so, yeah, I can see the attorney wanting to massage and tweak that language a little bit. I, the defendant, have a right to know, want, and need to regarding my case. All information is important, relative, and necessary to me. Again, I appreciate the point she has here that she wants to be at any hearings having to do with her case. I am not consistently included in certificates of service and sent copies of any document being filed in court regarding my case, as requested numerous times by the defendant in writing, verbally in the courtroom, neither by the judge, the court, or my attorneys. By attending, I will know what documents have been filed, need to be, and will be for and in my case. Because there is no mention in this letter about this new expert that they want to use to potentially pitch this battered spouse thing or whatever she's going to, battered partner thing or whatever it is she's going to try. In complete overall support, it is my right by law as an individual, defendant, and inmate to be included in any and all developments made in my case. It is also my right to finally achieve success in any and every aspect possible in my case. Cool motion. By attending and being included in my pretrial conferences and hearings, said success can and will be accomplished fairly, faster, and properly. Wherefore, the defendant, Sarah Boone, respectfully asks the honorable court to grant my motion to be included going forward to all defendants' pretrial conference and hearings. And then that's by her, but it would need to be, of course, by her attorney if she's buying through her attorney, or whatever. And then she's got a certificate of service on here, which is kind of interesting to do. That a copy of this document be filed in the Florida e-portal, the state attorney and all attorneys and any other parties on record, 19th day. So there's Sarah's correspondence, and she is consistent in her attitude with this, but she, her attorney has done some things, including ask the court for this new expert, and I don't know, can't remember. I don't think that's been ruled on yet, but he did move forward with it and has gotten a firm trial date, which is not too far. But according to her, they've only met the one time, and she can't get him on the phone. So, if that's true, I understand she doesn't like that. So I guess we'll see what happens here. But eventually, you have to begin to wonder who's really the issue here. What's really the problem here? And I don't know, when she's meeting with these attorneys, how the conversations are going. And if it's more about this kind of stuff, or if it's about actually getting the case together and getting it to trial, and considering what your options are, asking the state for a plea, being adamant that you're not going to plea for anything, you're going to take it to trial, and what your possible defenses are if that's what you're going to do. So anyway, I don't know what's going to happen next, but I would doubt that this is the last we'll see of her. There's a potential this moves on towards trial in May, but there's also potential that this rupture between her and her attorney becomes greater, and you could see another potentially motion to withdraw if she's going to start talking junk about the guy all the way toward trial. How's he going to handle that? I mean, how should he handle it, right? So it could be another disagreement here, and I guess we'll see what happens if that happens. But she's nothing if not consistent, and her pen is certainly admirable in terms of its ability to perform under dire and unceasing conditions and commitments. Well, that's it for Sarah Boone at this point. Go Booners, and we'll talk to you later. Bye.